Did your attorney advise you of that? And then an issue of the IAC comes up, and we're going down the wrong track, wasting a lot of time and resources. So it's probably a good idea to, in court, on the record, ask the court to advise the client of the notice of intent requirement.
Absolutely. Really, you want to, don't, because inevitably, you know, if we're arguing, oh, as appellate counsel, court didn't orally advise the client, our opponents, the county's going to come back with, but did the client otherwise have actual notice informed by counsel, and then we got to come back to you for it. Anyway, don't play advocate with review rights is really the motto. Because, you know, you want to make sure, if something unfavorable has happened to your client, if the result is unfavorable and or your client wants review, make sure all the I's are dotted and T's are crossed so that there's no monkey business that's going to interfere with your client getting review ASAP. Advocacy just goes out of that. You know, just doggone it, judge, get that doggone oral advisement out. You know, period. If the court doesn't do it, then we'll get, you know, the real nice record that you have made, and we'll take it up to the court of appeal, then we'll get a published opinion saying, juvenile court judicial officers, would you please comply with, so, okay. Anyway, you might want to write down the writ attorneys on this writ line here. I mean, this must include any ICWA error. Isaiah W. Sorry about that. Okay, arrest warrants. Hey, okay, guys, look. You know, we really gotta really get up to speed with arrest warrants. Okay, an arrest warrant is issued. You know, there's a 339 section. Welfare Institutions Code Section 339 arrest warrant. There's also the Wallace warrant. You know, Wallace was a Ninth Circuit Court of Appeal decision, you know, out of, years ago now. And then we have protective custody warrants. And thanks to, let me back up. There was always statutory authority for a social worker to take a child into protective custody. Statute mentions nothing about a warrant. Basically, social worker, you know, has got cause to leave, you know, the child's, you know, at risk. Social worker by statute, authority to take the child into protective custody. Well, the situation started, you know, getting a little more aggravated. You know, social workers started getting a little concerned about their personal safety. You know, they go to the police or the sheriffs and say, hey, would you guys come along with me? Well, of course, sheriffs and police know very well what they say. We're talking about Fourth Amendment search and seizure here, and you know, people. Hey, you know, you can't just start seizing stuff, you know, and you can't just start walking into people's homes. So police started getting nervous about it, and then you've got the parents who get really ticked off about it. They sue everybody. They wind up in federal court in the Ninth Circuit, and the Ninth Circuit says in Wallace, W-A-L-L-I-S, hey. This ain't going to happen here, guys. You need a warrant. So that's why you see in the juvenile court case file now these applications for protective custody warrant, and they very much are an attempt to mirror a law enforcement's application for a search warrant or arrest warrant. Okay. Now, what's one thing that a referee can't do without a judge signing off?
They can't do anything.
They can't do anything. That's right. They can go to the bathroom. That's why they cannot remove. Guess what? A referee Mordetsky can make an order of disposition, removing the child from parental custody. But that order by a referee has to be approved by a judge. There must be a sign off on that by a judge. Well, what's happening down here is some referees are issuing warrants. They're issuing arrest warrants. They're issuing protective custody and Wallace warrants. There's a real problem with that. You need to look at these warrants is part of your discovery. And if you've got a warrant that was issued by a referee, you got to move to quash it. You got to say, whoa, object to the detention of the children. The detention or the taking of the child into protective custody was done, without judicial, lacking judicial authority. That has to be quashed. And we're missing that. However, we've got at least one brief on this issue. Again, we have a forfeiture issue, but we'll see where it goes. The other thing is, I'll give you a situation we have here where social worker goes out to the mother's home, speaks with the mother, speaks with other persons in the home, speaks with the kids. Kids look okay. Obviously, the social worker had a referral. And the social worker is not inclined to take the child into protective custody and tells the parents, tells the mother, no, not going to do that. And, I'm going to talk to my supervisor about whether to pursue this, whether to file a petition or do a, voluntary, family maintenance contract or whatever. And social worker leaves. Certainly the parent has got wind right now of what's coming down the pike, and so, doesn't move out of the country, but it moves. It's out of the house. By the time the social worker gets back, hey, where's mom? Well, I don't know, mother's not here, mother and the kids aren't here, blah, blah, blah. And so then the social worker files a petition. We go into court, there's Judge Downing, and the social worker says, well, I can't, has not noticed the parent, either orally or with a citation to appear. But look, hey, can't find mother, can't find the kids. And the Downing says, hey, okay, great. I'm issuing a warrant for arrest for the parent. Okay, kidnapping, right? Warrant for arrest for the parent, and a Wallace warrant for the kids. Well, the parent is busted, picked up on an arrest warrant. Gets the public defender's office. When the public defender's office calls, somebody says, is there some way we can get this warrant recalled here? Anyway, things have gotten a little out of hand down here with a very spontaneous issuance of arrest warrants and protective custody warrants from the bench. Okay, one problem is issuance of Wallace warrants. When I say Wallace, I'm differentiating. That's a social worker has followed the law, prepared an application for, to take a child into protective custody. It's we're talking the Fourth Amendment, Fourth and 14th Amendment, right? Okay, and it's signed by a referee. Watch out, object. Okay, the second problem is when you got this situation where, finally, an attorney is appointed. Obviously, the protective custody warrant and the warrant for your client's arrest issued before you were even appointed. Okay, that's the way it works in criminal land. Okay, deputy public defender is appointed after, the police have obtained a warrant, gone into a house, seized the drugs, and after they've broken down the door and arrested the client, right? Okay, just like in an adult criminal case, you, as counsel for a parent whose children or whose own person has been the subject of a Fourth Amendment seizure warrant or a warrant from the bench under 339 or 340, you got to look at the cause. You got to examine whether there's cause for that, because these warrants make records for people. They stay on people's records. They'll become part of the next the next report in the next dependency proceeding. 2010, mother absconded with kids, arrest warrant issued, mother arrested on, it looks really bad. Cleanup needs to be done. Dependency law 20 years ago was piddly-dum because there just wasn't much law out there. But it's become more complex as more lawyers have become involved with it, as issues have been scrutinized, as courts have become involved. And how do courts get involved? Courts get involved because you as trial attorneys file notices of appeal and notices of intent. That's how the Ninth Circuit got involved in California's statutory scheme that just allowed social workers to willy-nilly I'm here, let me in, and I'm taking your kid. Now, the California statutory scheme said that was cool. It's always said it was cool, and it still says it's cool. But guess what? There is a higher authority than the California statutory scheme, and it's the United States Constitution. By the way, we really do appreciate your written 355.1 hearsay objections. Some of you are citing to the Sixth Amendment, okay? The Sixth Amendment does not apply. You cite to the Fourth, say 14, because the Sixth Amendment specifically says in a criminal prosecution, so don't say, just don't write and don't say that over and over again in these written motions. My client has a Sixth Amendment right to, confront prosecution, if it's the wrong amendment. Just get that out of the computer, just get it out of the whatever it is, in fact, because I've seen it a few times and I thought, well, I better say something. It says, in all criminal prosecutions, all right? Doesn't say, and dependency too. So just go, the 14th Amendment, you have a right to a fair trial, due process, 14th Amendment, right to a fair trial, not to confront the witnesses, against me. So we're at 1-8. We've had a lot of questions, Tim, more than you're sure. How much longer do I have here? We're only on right there.
I'm confused.
You're confused.
Going back to the Wallace warrant,
Okay.
signed by a referee,
Right,
comes to court on arraignment day, and we think that's wrong,
right.
and we make a motion that it's wrong, and
You have the detention hearing,
and to
right?
return the kid right now.
Right.
Now, practically speaking,
Right. Ain't gonna
what do
happen.
you think's gonna happen?
Ain't gonna happen, but we just start, these are incremental developments, is to get people thinking, wait, whoa. It's like, nobody thought anything was gonna happen when the parents challenged the authority of the social worker to take their 2 kids out of their home in Wallace. It's gonna,
We might give them a civil lawsuit.
what's gonna happen? Well, what it is going to start doing basically is, if you start making these objections as trial counsel, we start as appellate counsel moving this area of law up the pipe. The wheels of justice turn slowly, it is true. It takes a long time, but it's got to start with trial counsel, so we can develop these issues and, wait a minute here, who the heck is issuing these warrants? And wait a minute, was there probable cause to issue an arrest warrant for this parent? Who, okay, she is, okay, an arrest warrant without any, application. What are we talking about here? And this person is we're expanding the law, okay? It is, is it going to make a difference immediately? Well, I'll tell you one thing. It could make a difference if you're able to say, and I want that warrant to be recalled in this record to state that the warrant was issued in error. That does potentially benefit your client, because unfortunately we have a lot of repeat offenders. Just like in adult criminal land, we got a lot of recidivism. Unfortunately, in dependency land, we've got a lot of parents who come back into court with, they're in there with child number 1, 2, 3, and they have produced, we reproduce during the proceedings, and we have, it goes on and on. So, you got to do something, right? You got to make life interesting. But these are valid points, really, so hi.
So we've had cases where the parents come and they say, I wasn't given an arrest warrant or a protective custody warrant.
Right.
The social worker said if I didn't hand over my child, then I would be arrested. But there's no warrant that was ever signed.
Right.
So do we just put that on the record when it comes to
Yeah,
court?
absolutely. So, Your Honor, I want to go to detention hearing. I want to call my client as a witness here. And,
well, there's not even one in the packet that it was ever
right.
signed.
That's fine. Yeah, we're going to, and we're going to ask for discovery. I'm requesting discovery. Yeah. Make them sweat. They make you sweat, right? You walk in there every day. My God, what in the hell are you going to say in defense here? What in the hell am I going to say in defense of this situation? It's god awful. All right. So look, when you haven't got the facts with you, see if you got the law. It's true. It really is true. I'll tell you one thing also, you have a lot of judges down here, and they may not know dependency law, but they're used to a whole different ballgame of law being thrown at them. They are used to, this kind of law litigation, I'll say, you know. I think my sense is would maybe more receptive, and I mean, this is not to put down anybody, I mean, but just the judicial experience they bring to the juvenile court is vast. And I think some of these judges will be more receptive to this type of litigation. Okay, so let's see here. I guess everybody, one of you, Marlene first said this. You know, I put here, if you've got an incarcerated parent and either you believe there's an arguable, if the review is necessary, sign the notice of intent for the incarcerated parent or the notice of appeal. Don't send it to them in the mail. I mean, you know, too many things in prison mail is horrible. It results in delay. People are illiterate. Please sign the notice of appeal for them. I mean, we will get, you know, I've got a guy a month ago said, well, and of course it happened in the end of December 2012, you know, well, you know, yeah, I got the notice of appeal, but I think I got the notice of appeal after the time passed, and, you know, well, then I got to write you and say, you know, gee, do you remember this client that you had? And he says, you know, yeah, I sent it to him. Anyway, so forget that. So, okay, or no, I don't want to say presume. I don't want to say presume. Let's say biological parent. Okay, time and time again, you go into court, you've got a mother. No doubt she's a mother, but the father is alleged. Every once in a while, you got a guy who comes into court, right, with the mother. The petition says he's the alleged father. Mother fills out the paternity questionnaire and says he's the father, only man I ever slept with in my life. And the man comes in and says, yep, I was celibate until I met her. And his mother is with him, you know, the paternal grandmother's with him, and he says, you know, gee, I'd really like to have custody of him. And, but, was your name on the birth certificate? No. Were you present at the birth? No, I wasn't, because I was down at, Boucher Street overnight, at his birth. And has paternity test been done? No. Well, I find you're an alleged father. Well, that can be a real, wait a minute here, whoa. There's unrefuted evidence, undisputed evidence. This man is the biological father, okay? A paternity determination must be made, okay? But the rule of court and appellate case law says that paternity determination does not require an HLA test. So, you know, if you want to get that ball moving, and what ball do you want to get moving? You want to get reunification services in for this. You want to make sure this guy is deemed a biological father. Let's get those reunification services in place for the individual. So consider insisting on demanding a biological paternity finding on that type of evidence. When you're filling out a notice of appeal, remember to be guided, you know, as you must be by, you know, the rules, that is ordinarily an appeal can only review, you know, must be taken within 60 days, remember, except for the referee, you know, of the order's appeal. So don't write on your notice of appeal from the judgment from the order terminating parental rights on May 21st, 2014, and all orders and list all the dates from detention in September 2010 forward. It drives the juvenile court clerk's office nuts, it drives me nuts, it drives the court of appeal nuts. Why in the hell do we have a record like this? Okay, it's so stick with the rules there. We'd like to see as appellate lawyers more litigation of the relative placement exception to termination of parental rights. We see so many children placed with relatives, but we see little in the social studies. I mean, certainly we know the social workers are gunning for adoption, but we don't know whether the relative was fully informed by the social worker of, you know, look, there is an alternative plan here, and it's guardianship. And this is what guardianship means. So maybe, so you have the opportunity to serve as a guardian of